Hey Siri, send a message to my wife. I'm live on YouTube here in a moment.
Your message to Crystal.
Okay, good morning, ladies and gentlemen. We're here in the Franklin Circuit Court, and the court has set this matter just for a quick status conference to make sure so that I can make sure that I'm up to date on a couple of issues that I wanted to share with with council and to get some input from council about the status of their efforts. So just for the record, we're here in case number 21 CI 89, Governor Beshear versus Speaker Osborne and others. And I did want to, as you all know, I'm working on the pending motions that we had a hearing on a week before last. And I did want to get a report from council. I know you all are aware, I've asked you all to meet and confer to see if there was some either partial or complete agreement that could be reached with regard to any of the issues that are pending before the court. And I've previously expressed my view that obviously I think you all and your clients can in the long run reach a better resolution of these issues than the court can. And so I'm hopeful that you all will be able to address some or all of the issues before the court through, again, negotiation and compromise and settlement. And so before I issue a ruling, I did want to get up to date on the status of those discussions and to find out if there's any prospect that some or all of these issues may be in the process of getting resolved. So I would like to just open the floor and let council advise me of where we stand with regard to those questions.
Good morning, Your Honor. Amy Cubbage here. Mr. Fleener and I have had some very good discussions about trying to get a framework for attempted discussions on the COVID-19 aspects. And obviously I will let Mr. Fleener speak for himself. Those are productive and moving forward, but it will not be completed by the 4th. And those discussions have not addressed the statutory changes, but merely the COVID-19 aspects and the prospect for the legislature affirming or not some of the governor's actions related to COVID-19.
Okay. Okay, Mr. Fleener, any insight you can share with the court on that?
I would echo Ms. Cubbage's remarks. We've had some substantive discussions. The filing that the governor's office made of the orders and regulations, which they feel like are at issue, was very helpful. We have been spending some time working through that. Our hope is that, whether this case goes up or not, that we're able to, there are a lot of those executive orders and regs that we may be amenable to extending and making sure that the governor has the ability to continue to deal with the COVID matter while this thing may be pending in an appellate court. I think it's probably safe to say that there's going to be a couple of issues that we're just not going to be able to resolve. But that doesn't mean that we can't work together and get some things in place. Gosh forbid I win at the appellate court and then all of a sudden the governor doesn't have any powers to do anything. So we want to make sure that we allow for those possibilities. And
sure,
like I said, on that list, which is about 25 pages long, there's a lot of them that I don't think we'll have any problem extending their authority to do those immediately. And that can be done, we think, by just a simple joint resolution among the two bodies. But we are continuing to work. I would ask you to hold our feet to the fire for a few more days, and maybe we can make a little more progress.
Yeah. Okay. All right. Oh, okay. Well, that's very helpful. Any other council have any additional insight for the court on that? Mr. Maddox.
Eric Lycan on behalf of the speaker. Just like to echo what Mr. Fleener said and let the court know the vehicle, the joint resolution, the vehicle is going to be contain the end product of these discussions has been filed and is starting to move.
Okay, so there's an ongoing effort in both houses, it sounds like, to address those issues. So, okay. All right, Mr. Maddox, anything that you wanted to add on behalf of the Attorney General's office.
Morning, Your Honor. Nothing substantive. We think it's certainly appropriate that the legislature and the governor work out any differences they might be able to work out. We haven't changed our position on the case and controversy issue and are looking forward to the governor's brief.
Yeah, okay. All right. And Mr. Wolseley, I assume LRC is in agreement with the speaker and the president about the ongoing discussions, and that reflects LRC's position as well, I assume.
Yes, Your Honor. And as Mr. Maddox stated about their ongoing objections, we continue our position that we're not a proper party to this case. Yes.
Okay. Okay. Let me ask, Ms. Cubbage made the distinction in her comments about the COVID issues as opposed to the statutory changes. And I wanted to make sure I understood the distinction she's drawing there. If I could ask her to elaborate on that just a little bit more.
Of course. As you know, the House Bill 1 was essentially COVID specific. It mentioned, communicable diseases, but it's pretty obviously COVID related. But Senate Bill 1 and 2 are structural changes to the statutes that are not related solely to the COVID emergency. So for instance, there has been an order issued mid-February related to the ice storm. I do believe there is a joint resolution or a bill proposed to extend that already. There was an executive order issued last night related to the rain and flood event that we have going on now, that now under Senate Bill 1 would expire on March 30th. So there have not been discussions either related to other orders or to that underlying statutory framework that is the subject of the challenge ultimately here. So that issue would still be live even if we came to an agreement at least
On the COVID orders, yeah.
COVID part. Yeah. That's right.
Because again, the broader issue with regard to the structure of the legislative oversight is the 30-day limitation on executive orders and emergency regulations that are not extended by action of the General Assembly.
That's correct. And we also now have the order from Boone Circuit from the parallel litigation that we mentioned that I don't believe any of us are parties to. The litigation by some parents of Boone County Schools, of school children where they asked for an injunction requiring 5-day-a-week education. In that order, and I can't purport to have studied it in depth, though I have read it, the court appeared to take a contrary view to what the legislative defendants here had proposed as part of the argument that we've had here, and said that some of the governor's prior orders regarding education were already abrogated and were no longer in effect as a result of Senate Bill 1. Whereas here we were working on a 30-day.
30-day, yeah, understanding, yeah, okay.
So we've got some confusion, I think,
sure,
that's being introduced as a result of that.
Yeah, okay. All right. One other thing I wanted to ask about, just to make sure I fully understand the position of the parties, is Mr. Fleener did make a filing with regard to some of the regulations, not a whole lot, but he identified, I think, some of the regulations that that I think in the view of the Senate president anyway, are not, that were listed by the governor as being affected by the challenge legislation, that I think in his view may not be subject to those provisions. I just wanted to make sure I understood his filing on that. So if Mr. Fleener could elaborate a little bit about the list of regulations that he filed with the court.
Our position on those, and I think there's a big bone of contention on Senate Bill 2 with that 30-day restriction on public health regulation, emergency regulations. And I just wanted to point out that there were a lot of regulations on their list that did not come out of public health that we would be of the mind that the 30-day restriction didn't apply to those.
Yeah.
So I just wanted to make that clear.
Yeah, so it's your all's view that the regulations that were not promulgated under Chapter 214, the
Right.
public health statute, are not impacted by that 30-day.
That's correct.
Okay.
I would also point out some good news for Ms. Cubbage that on those localized emergencies like the ice and the flooding, that it's their position that they have the ability to deal with those, just dealing with the specific county judge executives, and they don't have to bother the legislature with that at all. So I'll throw that in.
Okay. Okay, and Ms. Cubbage, anything with regard to the point that I inquired about with Mr. Fleener regarding those regulations that he pointed out in his filing were not Chapter 214 regulations?
Yeah, and I unfortunately I apologize. I don't have that up in front of me right here, but it was our interpretation of Senate Bill 1 and 2 together that Senate Bill 1 would have affected those, and that those were at risk of expiring. But you know, whether
Okay.
those continue or not, that was a very small fraction. Of
Yeah,
the,
right.
legislation.
And you know, I think clearly some of these regulations are going to fall into a gray area where you know, there may be some dispute about whether about how the legislation affects them. So, but again, I wanted to make sure I understood Mr. Fleener's point, which I think I do now, that the regulations he listed were not promulgated under Chapter 214, the public health statute, and then so arguably they're not affected by the 30-day clock that is ticking. Okay. Well, all right. Those are things I wanted to check on, and I wanted to again encourage the parties to continue their discussions and negotiations. And I will say that I do think it's important for the court to get a ruling out to you prior to the expiration of this 30-day time period that we've been discussing, and I'm expecting to have that ready to go within that time frame, and hopefully in the next couple of days I will have that ruling for you. I wanted to make sure I understood the issues that I inquired about here today, and also wanted to continue to encourage the parties to continue their discussions about any kind of resolution that they can reach, again, of some or all of the issues. The more issues that the parties can agree on, I think the better off the public will be. So I want to encourage that, and I want to make sure that I don't do anything that would be an impediment to the parties continuing work to try to resolve as many issues as possible. So I will again take the matter under submission and try to get you all a ruling here now in the next couple of days. And I appreciate on the issues I inquired about, and will encourage you all to continue your discussions, and also reiterate that the court is, you know, it will be receptive at whatever stage of the litigation as you all continue your discussions to do anything the court can do to facilitate the parties reaching agreement on as much as possible. So with that said, I will we can go ahead and stand in recess. I want to thank you all for your input, and I will be getting you in order very shortly. So thank you very much.